First, dissolution by agreement. A firm is a creation of an agreement between partners. Partners may agree to terminate the firm and the firm shall be dissolved. So, this is when the partners mutually agree with each other to dissolve the firm. And all of them agree that, okay, the firm has to be dissolved. The firm gets dissolved. Because it was these partners who formed the firm. So they have the right to dissolve the firm, and each one of them, if agrees to this point that the firm has to be dissolved, they mutually agree, there's unanimity, there's consensus between them, the firm will get dissolved by mutual agreement. Next, compulsory dissolution. Now, what do you mean by compulsory dissolution? Compulsory dissolution means you have to, by hook or by crook, dissolve the firm. Compulsorily dissolve it. There's no other way. There's no other option. So the firm will get dissolved. When? Let's see. The Partnership Act 1932 provides that under the following circumstances, the firm shall be compulsorily dissolved. So what are those circumstances? First, all the partners are declared insolvent. If all the partners become insolvent, the firm gets compulsorily dissolved. Now, can you think of a reason as to why such a point has been kept? Why does a firm need to be compulsorily dissolved if all the partners become insolvent? The logic behind this is an insolvent person means that he is incapable to meet his liabilities. His liabilities are more than his assets. So, tomorrow, if such a person takes a loan, purchases some goods from others, what he is doing is he is incurring more liability. He is taking up more liability. At first place, his assets are not enough to pay off his liabilities. He knows that his liabilities are more than his assets. And to add to it, on the partnership front, he is taking up more liabilities, because the liability of partners is joint and several. So he's severally, individually also liable for the liabilities of the firm. He's not competent, or he does not have the potential to pay off his own liabilities. No, there's no question of paying off the firm's liabilities. That is, like, that would be foolish if such a thing is allowed. So insolvent person has been made incompetent to contract. We have done this in Contract Act. He cannot enter into contracts, because in a contract you make a promise and you get something in return. When you make a promise, what you're doing is you are taking up a liability. You'll give something, you'll get something. But an insolvent person is incapable of contracting any more liabilities. So he has been barred from making contracts. He cannot make contracts. And since in this firm all the partners are insolvent, they cannot make contracts, they cannot contract liabilities, how can they run the firm? It's very easy to understand that they'll not be able to do business. So in such a case, it is advisable that the firm be dissolved. Okay. Next, all of the partners except one are declared insolvent. Now again, there's a logic behind this. The first case spoke about all the partners becoming insolvent. The second case talks about all the partners except one. So let's say if a firm has 4 partners, 3 of which are declared insolvent, but 1 is solvent. In that case also, even in that case, the firm will be dissolved. Can you think of the logic again? The logic is partnership is a relation between two or more persons. But here, there's only one person who is solvent, who will be able to do business. Then, if one person has to do business, it becomes a sole proprietorship. It doesn't remain a partnership, it gets reduced to a sole proprietorship, and thus the firm has to be dissolved. Because others anyway won't be participating, they are insolvent, they won't be contributing, they won't be deciding, they won't be managing, they won't be entering into contracts. There's only one person who will be doing all this. So he might as well start a sole proprietorship than a partnership, because partnership requires two or more persons who manage the business, two or more partners. But the other partners then become unqualified to act as partners because they are insolvent. Okay, so even if one remains solvent, the firm still has to be dissolved. And finally, the business carried on by the firm becomes unlawful. The business which the partners are carrying on has become illegal, has become unlawful. How can the law permit such a business? It cannot, so the firm has to be dissolved. Let's say A, B, and C were in the business of selling wines. Suddenly, a government circular came which banned selling of wines in that state. And if they continue with that business, it will be unlawful and illegal. Such an act won't be allowed. So it is, there's only one option left, that is to dissolve the firm. Third mode, contingent dissolution. Contingent dissolution matlab, contingent dissolution means some contingency has arisen which is making the firm get dissolved. Something has happened, some situation has come up, some circumstance has arisen, has come up, due to which now the firm cannot continue. So let's see, when does a firm get dissolved because of contingent situation coming up. First, if the firm is constituted for a fixed period, on the expiry of that term, the firm dissolves. So if the firm was formed for, let's say, a year, now if the year has elapsed, the year is over, the firm will have to be dissolved. So it will lead to dissolution of the firm. So if it's a particular partnership and it was made for 1 year, it gets dissolved after that year. B, if it was constituted to carry out one or more projects, on the completion thereof, it dissolves. So, if it was a particular partnership formed to complete some object for some purpose, and when that work, the purpose, the object is complete, the firm gets dissolved. Okay, so this is pretty simple to understand, that if it's a particular partnership may be, because of two reasons, either because of time or because of purpose. So when the time is complete, the firm has to dissolve. When the purpose is complete, it's done, the firm has to dissolve. If the partner of the firm dies, now if one of the partner in the firm dies, the firm has to dissolve. Now this is very important to understand. On death of a partner, there is, almost like a compulsory dissolution. You have to call it a compulsory dissolution. But since when the partner will die, it is not known, it comes under contingent dissolution. Because dying of a partner is a contingency. You never know when it may happen. It may happen, tomorrow, or it may happen after 20 years. You never know. So it's a contingency. So whenever it happens, you will have to compulsorily dissolve your firm. If a partner of the firm is declared insolvent, Now again, we have discussed this point in compulsory dissolution, but the declaration of partner as insolvent is a contingency. You never know when it may happen. So whenever it happens, then it becomes compulsory dissolution. Okay. Now in the first 2 points, we said if it's a particular partnership formed for some term or formed for an objective or formed for a project, and then either the time or the project is complete, the firm has to dissolve. Let me tell you, the firm ideally should dissolve, but it may not dissolve in all cases. The partners may want to continue with the firm, and if they continue with the firm, then their rights and liabilities remain the same. They also continue their rights and liabilities. Okay. Next, dissolution by notice. Now, many a times a partner by his own will may dissolve the firm. He possibly is not comfortable with the firm going on. He is not comfortable being a partner. So rather than moving out of the firm, he tries to dissolve the firm. Because what happens is many times we think that this firm is my baby. I started this firm. So if I am not there in the firm, no other person should run this firm. So what he does is he dissolves the firm. He can do it because he was the one who formed it with other partners. So he can always dissolve the firm. Now if the other partners want, they can start their own firm excluding this partner. But this firm will have to get dissolved if this partner who's unwilling gives other partners or the firm the notice of dissolution. Where the partnership is at will, the firm may be dissolved by any partner by giving a notice in writing to all the other partners of his intention to dissolve. He has to give a notice in writing. The firm is dissolved from the date mentioned in the notice as the date of dissolution. So when he is giving them a notice, he write a date there, that from this date the firm stands dissolved. What if he's not mentioned the date? Then the date of the notice becomes the date of dissolution. Whenever the other partners get this notice, that date itself becomes the date of dissolution. Okay. So if no date is mentioned, date of communication becomes the date of dissolution. Where date is mentioned, the mentioned date becomes date of dissolution. Next, dissolution by court. Now, court also gives the orders for dissolution. In what cases? Let's see. First, insanity. That is, the partner becomes unsound. We've studied an unsound person is incompetent to contract. And when he's incompetent to contract, he's incompetent to enter into agreements. Partnership itself is an agreement. He'll not be able to carry on, with it. Because a partner has to make contracts with partners, contracts with debtors, contract with suppliers, contract with many employees outside agencies. So if he's incompetent to contract, the partner has become unsound, then they cannot carry on the firm. So if this partner goes out from the firm dissolves. The remaining partners may form a new firm and then they may want to continue. Okay. Next is permanent incapacity. Now, what do you mean by permanent incapacity? Permanent incapacity means, let's say there were 3 partners in a firm, L, M and N. N, while going home, met an accident with the train and both his legs got cut. Now he has been rendered permanently incapable. He is permanently disabled. There's no way he can, run on his legs now. So because of this reason, he may be, he actually he cannot continue as a partner in the firm, and thus the firm will dissolve. Or there may be a case wherein, you know, he met with an accident, and there was a shock that he got on his head, and now he does not remember anything. He's lost his memory, he's lost his eyesight, or possibly he is now not able to rationalize things. He's not able to make decisions. So there is permanent incapacity. The important thing here is permanent. It should not be temporary. Because it is temporary, the person will revive and he'll come back to normal. The important thing is the incapacity should be permanent. And then if it is permanent, the firm will dissolve. Next, misconduct. That a partner or the other partner suing is guilty of misconduct which is likely to affect prejudicially the carrying on of the business, regard being had to the nature of it. Now, what does this mean? This means that a partner, he is guilty of misconduct. He is guilty of some misbehavior. He possibly, has had a bad behavior with partners, had a bad behavior with, other parties like customers or suppliers, or possibly he has, done some frauds. So there is misconduct on his part, and because of this conduct, it is likely to affect prejudicially. Prejudicially means negatively. I'll write it again. This means negatively. So, because of this behavior of his, the business of the firm is being negatively affected. The sales are going down, they are incurring losses. So, it is better to remove that partner. And once the partner is removed, the partnership gets dissolved. And if they want the other partners, they can form a new firm and continue. So these are the cases where court decides that the firm has to be dissolved. First was the case of insanity, second was the case of permanent incapacity, and third is misconduct. Next, breach of agreement. That a partner other than the partner suing willfully or persistently commits breach of agreement relating to management of affairs of the firm. That is, the partner who has applied for dissolution, other than that partner, the other partners who are left, either all of them or one of them or a couple of them, have breached the partnership agreement. They are breaking the partnership deed. Whatever agreement, whatever clauses they had made, now they are not following it with regards to the management of the firm. So, it is a good ground to get the firm dissolved, because what was decided mutually is not being followed. The things that were agreed are being broken, continuously, persistently. This word is very important. Persistently, that means continuously. Willfully, that means intentionally. Okay. So he intentionally or continuously keeps committing breach of the partnership agreement relating to management of affairs. Now, let's say if one partner was given the duty of doing the accounts of the firm, and now he is not at all bothered about the accounts. He is willfully neglecting the accounts of the firm. The firm may be dissolved. Or I'll give you one more example, where one partner was entrusted with sales of the firm. So apart from sales, he is doing purchasing. He is looking after purchases also. He is doing accounts also. He is interfering in all the departments of the firm. Still, the firm may be dissolved because he had the power only to do sales for the firm. He is consistently, continuously breaching the partnership agreement. So the firm may be dissolved. The court may take it as a valid ground for dissolution. Next, transfer of interest. Has transferred whole of his interest in the firm to a third party or has allowed his share to be sold in execution of a decree. There's a partner who has transferred his interest completely to some other person. See, partnership is the agreement between the partners. So whatever you do has to be with the agreement of others. Now, if the other partners do not agree to you, transferring your interest to other person, then the firm has to be dissolved because you have done something which is not with the consent of the partners. Because the existing partners may not be comfortable with that other person as a partner in the firm. They may not want that person in the firm. So it's better to dissolve the firm and then the remaining partners may continue in the new firm. Or has allowed his share to be sold in execution of a decree. He has allowed the court to sell his share in execution of a decree. Execution of a decree means it is he has allowed the court to sell his share in the partnership firm. See, actually the court also does not have the right to sell his share in the firm. But if he has allowed the court to sell his share in the firm, and as per court order he has sold his share in the firm, then the firm will have to do because as I said, the existing partners may not be okay with the new partner coming in, may not be okay with the share of this partner going to some other person. So the firm may be dissolved. The court may find it a valid ground to dissolve the firm. Losses. This is very easy to understand. This is very logical that if the firm is continuously making losses and in the future profits cannot be anticipated, we cannot see that if we continue with the firm and we make profits, this firm can exist, can survive, can be managed only at losses, then it makes all the more sense that the firm be dissolved. The court will immediately give a dissolution order if sufficient evidence is produced that this firm can only be run by making losses. In future there is no possibility of profits. And finally, just and equitable cause. As I said, this is a residual clause. So any other reason which the court may find just and equitable, it may find reasonable to dissolve the firm, it will be accepted. So some examples of it are given as deadlock between the management. There are two groups that have come up in the, between the partnership, I mean the partners. Let's say there are four partners in the firm, A, B, C, D, and A, B are on one side and C, D are on other side, with regards to the type of business that needs to be done. A, B are like, the nature of the business needs to change from, our business in oils, we need to get into clothing, but C and D want to continue with this business only. So there's a deadlock between the management and it is not being resolved. So if there's some deadlock which is beyond resolution, the court may accept it as a just and equitable ground for dissolution. Okay, partners not in talking terms. Now again, there has to be mutual trust. The relationship has to be strong. There has to be, friendship. There has to be a friendly behavior between partners. But if the partners, are facing animosity with each other, are enemies of each other, they are not at talking terms, the partnership should rather dissolve. The partnership should rather dissolve, because such a partnership will never be a success. The partners won't be able to sit down together and make decisions regarding the firm's affairs. They are not at talking terms. Then what is the use of coming together and forming the partnership? Then it's better they run their sole proprietorships. They both dissolve the partnership and run their sole proprietorship business. As simple as that. Loss of substratum. Substratum means faith. So if the partners have lost faith in each other, they do not trust each other, then it's better to dissolve the firm, because partnership is, something which requires a lot of trust between the partners. They need to be faithful to each other while running the business. At the same time, the other partner needs to have faith and trust in him that he is working in the greatest common advantage of the firm. But if the partners have lost faith and trust amongst them, the firm surely will get dissolved sooner or later. So the court may find this as a, valid ground, as a just and equitable ground for dissolution. Gambling by a partner on a stock exchange. Now, the firm was formed to do business. The firm was not formed to do gambling. If a partner is doing gambling, he might, leave. He might leave the firm, or the firm might get dissolved. In either case, the firm has to get dissolved. If the partner leaves, again the firm will dissolve. If the court orders that the firm should be dissolved because of this reason, the firm gets dissolved. So in either case, the firm will dissolve. So these were the grounds of dissolution of a firm. So